Wang, and my Wang is my last name. Chang is my first name. I'm a practicing attorney and a law professor. I'm currently speaking with you from St. Paul, Minnesota, where I have been stuck in for the last 2 years. I have never been in Minnesota for this long. Today's talk, we will have 3 parts. Part 1, we will do a brief introduction. Part 2, we will put China's civil code in the historical context. And the vast majority of time, we will begin to look at the different parts, different books of the new civil code. Let's start with the Civil War, shall we? 1945 to 1949, that was the China Civil War. 1949, the People's Republic of China was founded. 47 to 52, that was the land reform. What does it mean, land reform? That means the elimination of private ownership of real estate. This is so important because that is the most difficult part to understand China's property law. Because in China, the land have only 2 types of ownership: state-owned land or collectively owned land. You can roughly translate as community-owned land. There is no private ownership of any piece of land. You cannot go to anywhere in mainland China and buy a piece of land. You can only lease on it. That was not true before 1947, because before 1947, for thousands of years, there was private ownership of the land system, both in Imperial China and Republic of China. But land reform started in 1947, lasted until 1952, completely eliminated the private ownership of the land. 1950 to 53, that was a Korean War between North and South Koreas and China and the United States and United Nations. You all know that. That was important to our discussion because that China, at the beginning of the People's Republic, China was considering which legal system in the world they want to learn from. And the Korean War basically eliminated the possibility to learn from the United States. So in the early part of the People's Republic, China's legal system was very much copied from the Soviet system. 1966 to 1976, that was the Cultural Revolution. And in the history books, you probably know something about it. That is also important to our discussion because for the entire 10 years, there was no legal system in China. The entire legal system was eliminated during the Cultural Revolution. There was no courts, there were no prosecutors, there were only police, and there was no criminal defense. The legal profession was eliminated, law schools were eliminated. I know it's hard to fathom, but that was the reality for these 10 years. 1969 to 1978, youth to the countryside, which means the high school graduates did not have opportunity to go to college. They were sent to the countryside to live and learn from the peasants and the farmers. So the China's higher education only resumed after 1978. College admission was restarted in 1978. 1972, Richard Nixon visit in China, but the United States and China did not establish diplomatic relationship until 1979. 1976, Prime Minister Zhou Enlai died, Chairman Mao died, and the Gang of Four were arrested. China started a new chapter. But the new chapter was not really officially started until 1979. The Communist Party of China implemented the open door policy, reopened China to the world, economic reforms, reforming China from planned economy to quasi-market economy, U.S.-China food diplomatic relations established by President Jimmy Carter and Deng Xiaoping, and birth control one-child policy started. So here's a little trick. If you ask anybody, any Chinese, do you have siblings? My answer would be yes, I have an elder sister. Then you know for sure I was born before 1979. Otherwise, I wouldn't have a sister or brother. On your left, that is downtown Beijing map. That is my city. This is the Tiananmen, the gate of heavenly peace. This is the Forbidden City. The second ring road, the third ring road, and the fourth ring road. And outside this map, you will see the fifth ring road and the sixth ring road. It's a vast city. Anywhere you'll see people. There are at least 22 million residents in the city of Peking. I was born somewhere between the third ring road and the fourth ring road in the northwest part of China, where the Beijing, where all the universities, colleges, research institutes clustered. And if you go to the eastern part of China, Beijing right now, you see a lot of bars, clubs, and luxury goods shops. Let's put China's legal system in the historical context. The written history of China roughly started in Shang Dynasty. And there was a Xia Dynasty, but we don't really have a lot of artifacts and written material to verify its existence. The Imperial China lasted a long, long time, 3,000 to 4,000 years until the end of Qing Dynasty, 1911. So those are the Imperial China dynasties. The legal system was very well established during this time, but it was completely different from the legal system we are talking about today. There was no very coherent consistency from the Imperial Chinese legal system to the current legal system. Let me quote Professor Jerome Cohen from New York University, his observation of traditional Chinese law. Traditional Chinese law was mainly an instrument for enforcing status-oriented Confucian social norms and for bending the will of unruly populace to achieve the purpose of an authoritarian government. To these ends, it provided a complex series of punishments and an elaborate hierarchy of institutions for adjudicating guilt and passing sentence. These institutions relied on orderly but highly repressive procedures that allowed the defendant little opportunity to make a defense. In other words, traditional Chinese law were criminal law and administrative law in nature. There was very little civil law and there was very little commercial law. One legal historians even put it to the extreme, and I quote, every single human behavior recognized by traditional imperial Chinese legal system was linked to a punishment. Just think about this sentence. Every single human behavior recognized in traditional Chinese law was linked to a punishment, which means the law was criminal and administrative in nature. But I would argue that there was still a lot of civil law and commercial law existed in Imperial China, but they were not systematic and they were not consistent. So we encounter the first concept. It's very important to traditional Chinese law, that is rule by law. You all know what is rule of law, but the rule by law is a different concept, which is predominant in traditional Chinese legal system. Rule by law is a concept that sees the governing authority as somehow being above the law and has the power to create and execute law. Were defended to be convenient despite the effect it has on larger freedoms that people enjoy. To expand on this idea, rule by law is a method that the governments and the people in power use to shape the behavior of people, and in terms of governing a country, mass groups of people. To distinguish between rule of law and rule by law, there is a very simple test. Can you identify any individual, any organization, or any entity in this particular country or region is immune to the legal system? In other words, is there anybody, any entity, or any party you cannot sue in a court of law? If you can identify such individual, such entity, or such political party, which means this country is a rule by law country. It's a not rule of law country. For example, in Imperial China, Qing Dynasty, you cannot go to a court and sue the emperor. You can't. You'll be arrested and probably executed. So, but in the United Kingdom, you probably can sue the king because of Magna Carta from the Middle Ages, because the Magna Carta established the principle of rule of law. Nobody is above the law. Everybody is subject to the rule of law, even the king or the queens. And if they want to take your property, take your liberty, they have to follow certain procedure. This is called due process. But this concept was not existed in Imperial China and many other countries in the Middle Ages. Now we quick fast forward, jump to the People's Republic of China. From 1949 to 1979, the first 30 years of the People's Republic of China, the law was viewed as a means to achieve larger party policy, a tool to facilitate the fledgling nation and to fight to rejections of the old evils and its transformation into a new socialist republic. The party controlled the state and created and used the law to regulate the masses, realize socialism, and suppress counter-revolutionaries. Sounds familiar, isn't it? From 1949 to 1956, a very strict Soviet-style legal bureaucracy was established. 1954, the first constitution in the People's Republic of China. Let me clarify, this is not the first constitution in Chinese history. Before that, there were many versions of different constitution starting 1909, even in the late Qing Dynasty. The late Qing Dynasty was trying to establish a constitutional monarchy very similar to the Japanese Empire, but the Qing Dynasty collapsed even before they could have opportunity to do legal reform and to establish a constitutional monarchy. The First Republic started in 1912 to 1949. They had many different versions of the constitution, and they still have a version of constitution in place in today's Taiwan, but obviously the People's Republic of China doesn't recognize Taiwan as a country, just a region. But our main focus today is the mainland China, the People's Republic, and 1954 was the first version of the constitution in the mainland. This version of the constitution provided a framework of legal system very much like what in fact in the Soviet Union from 1921 to 1928, gave the Standing Committee of the National People's Congress authority. A very simplified directive tailored to the needs of local communities so that the people and the new cadres could participate fully in their implementation. The party, the Communist Party, saw law as creating constraints upon its power and administration of justice, as a rival to the party control. So in 1957, the major parts of the legal system was dismantled. Same inclination to attack the legal system even greater during the Cultural Revolution, which means abolition of the legal system altogether. From the Cultural Revolution, from 66 to 76, the legal structure was abolished. By 1979, Deng Xiaoping regained power, initiated open door policy, and so in the 1980s, the legal system was re-established. So this is a very quite young legal system. The Ministry of Justice, law schools, and legal profession re-established. And the need for legal services drives growth in number of Chinese lawyers. You can see the legal system began to flourish. Today, they are, I think the last number I saw was about 300, more than 300,000 lawyers in today's China. In 1980s, they were a dozen. At the beginning of 1980, there were like 10 or 20 lawyers in the entire China. But today, there are more than 300,000 lawyers. That's still not enough. And compared to the United States, we just have too many lawyers. China needs more lawyers. In 1990s, the market economy took place. New laws and regulations were enacted to promote the market economy. Post-WTO in 2001, the very continued and broadened Chinese legal reform. So the legal system rapidly developing to support economic growth. That is takeaway number one. Number two, the civil code is a milestone in China, the legal system in China. But there are still a lot of room for development in the coming days. On your right, look at the chart on your right. Talk about the law. On the very top is National People's Congress. The National People's Congress promulgates and publish laws. There are two types of laws, National People's Congress law and National People's Congress Standing Committee law. Those are all statutes. So generally speaking, China is a civil law country, civil law tradition, statutory law. But the China official definition is not. We all know Italia will call itself a civil law jurisdiction. United States will call itself roughly mainly a common law jurisdiction. But China said we are neither civil law nor common law. The official definition of Chinese legal system is we are Chinese socialist legal system with Chinese characteristics, whatever that really means. But just remember that is the official definition of Chinese legal system, a socialist legal system with Chinese characteristics. So China, because of China has been heavily influenced by civil law tradition, so we don't have a precedent. We don't recognize stare decisis. So the court cannot make law. The cases decided by the courts, they are not laws. They are just guiding cases. They have persuasive authority. You can use them as a reference to enhance your argument, to strengthen your argument, but technically speaking, they are not laws. The laws are only the things published by the National People's Congress. State Council, the central government, or the executive branch, they publish regulations. They have ministries, and they publish regulations, and the provinces and the cities, they all publish local regulations and city ordinances. So those are the entire body of law according to the textbook. But there's a key difference between Chinese legal system, the socialist legal system, versus the legal system you're familiar with in Argentina, in Italy, in Germany. because in China, the Communist Party's directives is also law. They are as important as anything promulgated by the National People's Congress. So when you see anything promulgated or published by the Communist Party Central Committee of the Communist Party of China or the leadership from the party, please pay attention because they are important. They are very important to understand China's economic policy, political policy, and the diplomatic policy. So every year, you'll hear in the news, the National People's Congress is in session, or you'll hear the National Congress of the Chinese Communist Party is in session. They are equally important, and the Communist Party Congress, the documents, the directive published by the Communist Party Congress, they are equally important as the statutes published by the National People's Congress, or not even more important. So let's go to the civil code. The first civil code, this is what we are talking about, was the first civil code in the People's Republic of China and from 1949. The code was officially promulgated on May the 28th last year and effective January 1st of this year. The Part 1 general provisions of the civil law was promulgated in 2017, replacing the most parts of general principles of the civil law, which was promulgated in 1987. This civil code also replacing all the subject laws, marriage law, inheritance law, general principles of civil law, adoption law, guarantee law, contract law, rights in rem law, tort liability law, general provisions of civil law, all these laws previously promulgated by the National People's Congress in the previous decades. The drafter of the Civil Code was the National People's Congress Standing Committee, Legislative Affairs Commission, a very well-respected institution, consists almost of 12 jurists and law professors and retired judges in China. The vote, 2,879 yay, 2 nay, and 5 didn't vote. So I think you all have the same question: who the hell are these 2 people voted no, and what are they thinking? It was a very long legislative process, and even in the short history of the People's Republic, the first attempted to draft a civil code was in 1956. Remember, from 1949 to 1956 was China had a very strict Soviet Union style legal system. So they wanted a civil code similar to the Soviet Russia Civil Code in 1922. The first draft in 1956 had 400 articles divided into 4 articles, 4 parts: general provisions, ownership, death, and succession. The kingship chapter was included, and this draft did not stipulate property rights. Remember, there was no private property in China. So the first draft of Civil Code, they thought that it was unnecessary to include a property rights section. Replaced the concept of natural person with the concept of citizenship. So in the law only recognizes citizens. If you are non-citizens or deprived of political rights, you don't have rights. But in 1957, the anti-righteous campaign started. And what exactly was that? You can just simply Google that. That was the starting point of the endless political campaigns targeted to the educated class in modern China. In 1958, Mao issued a directive that neither the civil law nor the criminal law were needed. So the party's policy was it sufficient? So the first criminal law was promulgated in 1979. 1979, 30 years after establishment of the People's Republic, China promulgated first criminal law, was significantly revised in 1997. That is a version currently in use. And the first civil code draft, general principles, was promulgated in 1987, and the entire civil code only was promulgated last year. So as you see, everything we are talking about today is quite new and fresh. We're not talking about 1,000 years of legal tradition and the imperial legal system. The second attempt happened in 1962 to 1964. It was called the draft of the civil law, consists of three parts: general provisions, property ownership, and property transfer, with 24 chapters and 262 articles reflecting the planned economy doctrine. I know you have a question. There is no private ownership. Why you have two chapters, two parts on private ownership? Because of planned economy, the party want to ensure that the land use is effective, either state-owned land or collectively owned land. From 1965 to 1976, political campaigns and the Cultural Revolution stopped the second attempt to draft China's civil law. It was discarded. The third attempt happened in 1979 to 1980. Remember, China's open door policy, economic reform started. Law schools reopened. The Congress, National People's Congress, reopened. So they drafted 6 parts and 501 articles in general provisions, property ownership, contracts, labor remuneration, and rewards, liability for damages, and the inheritance of property. It was very similar to the modern and contemporary legal concept you are familiar with. But from 1980s to 1990s, Congress began to publish the subject laws one by one because they were not in the position to promulgate an entire civil code. So they thought we're going to start small. We're going to start with the different subject laws, and at the end of the day, we will have a comprehensive civil code. So the first, they promulgated the marriage law, then inheritance law, then general principles of civil law, then civil procedure, adoption law, guarantee law, and contract law. So by the end of the 20th century, the Congress believed that we are ready to put everything together to have a comprehensive civil code. That was the first attempt, civil law of the People's Republic of China. But there was a fundamental difference among the judges and the jurists. That is, whether or not to establish a personality rights and intellectual property rights. Because of these two major differences, they couldn't publish this version. What does it mean, personality rights and intellectual property rights? One group of jurists argued, we shall not recognize personality rights. And we will elaborate in the later slides. If we establish personality rights, basically we recognize civil rights. We are no different from the Americans. We need to differentiate ourselves from the other capitalist and bourgeoisie legal system. We don't recognize personality rights. Another group of jurists argued that is not uniquely, exclusively reserved by the Western European or American capitalist legal system. Personality right is a universal, fundamental human rights. So we have to recognize personality rights. So there was no agreement. Second, one group of jurists argued, we cannot recognize intellectual property rights. If we do, trademark, copyright, patents, trade secrets, we're going to lock ourselves, and we cannot fast grow our economy. Another group of jurists argued we have to recognize intellectual property rights. Otherwise, we cannot negotiate and doing business with all the Western countries and the rest of the world. For the second argument, the group of people promotes intellectual property rights ultimately won. So there were trademark law, copyright law, and patents law in China. But at the end of the day, there was no civil code. From the fifth attempt, started in 2014 until last year, personality right part was agreed in 2018. See, as soon as this part was recognized, that everything goes smoothly. This version of civil code was heavily influenced by German civil code and French civil code. The system of land, contracting, and land rights and interest underwent major amendments to the property rights. Major improvements in the part of marriage responsibility, but still no same-sex marriage. And in the new civil code, 30-day cooling off period for divorce was very controversial. So Chinese people, if they want divorce, they want to do it right away. No, that is a joke. Because there are some land restriction and some provincial and municipal property restriction. So some cities, big cities and provinces implement this policy. One family, and you can only own one property. If you want to buy two property, you need to pay a lot of tax. You want to pay three property, you need to pay even more tax. So as long as there's a policy and there's a strategy, the strategy of many Chinese family is, okay, let's get a divorce. Then we have two families and we will save a lot of tax. So you go to the civil bureau, you see a lot of happily divorced couple chit-chatting and get a divorce paper, and then they can avoid a lot of tax. But this 30-day cooling off period really make this process very difficult. Obviously, this is just an exception. That is not what I meant to criticize the legal system. But the 30-day cooling off period has been criticized by the feminist activists that is not respecting to the females' rights. Major conflict among lawmakers are personality rights, indeed civil rights. This controversy is still here. But at least the Congress said, no, they are not civil rights. They are just a personality rights. That is a compromise reached. So we now have a civil code. If they argue the personality rights are indeed civil rights, I doubt the civil code will be promulgated. There are 7 books, or you can call it chapters, of the new civil code. Book 1, general part. By the way, going now for the rest of the time, you will see these names of these chapters and articles. Sometimes it's very awkward. And this is not my fault. Those are official translation of the civil code. There are different, as soon as civil code was promulgated, there are different translations. The international law firms in the United States and in Europe began to translate. Law schools began to translate, but the only official translation, you have to wait until the National People's Congress. So all the translations are from the National People's Congress. And these people, they use, I think it will be prudent to use their translation rather than the American or British translation. The reason is some legal terminology, some vocabulary of very awkward, but they are uniquely Chinese. If you find American counterparts in English language, they are not the same thing. The awkward translation is just a constant reminder that it is important to recognize the uniqueness of the Chinese legal system. And we cannot look at something in China and say, oh, we have the same thing in the United States or in Europe. No, they are not the same thing. For example, to give you one example, many of my American colleagues look at China, said, oh, you have a Supreme People's Court. Okay, it's a judiciary. Then you have a state council, executive government. Oh, you have an executive branch. And you have a National People's Congress. You have a legislative. Exactly like what we have in the United States, separation of power, three branches of government, judiciary, legislative, and executive. And my answer would be, you got it completely wrong. There's no three branches of government. There's only one branch of government in China. That is the Communist Party. The party supervises judiciary, supervises legislative, and supervises executive. Everything goes back to the Communist Party. So be respectful. Don't think that they are checks and balances among different branches of government. No, no such thing. They are not comparable. So go back to our civil code. General provisions, natural persons, legal persons, civil juristic acts which fall into the jurisdiction of civil code. What is agency, civil liability, limitation of action, counting of periods of time, statute of limitation. So this civil code is, we would call, is very advanced, very scientific, quote by quote, because like many statutes in the Western world, is starting by definition. What is natural person? What is legal person? Give you a very clear definition of the legal terminology. This is very, very, very rare in Chinese statutes. So you have to say this is a huge improvement. Some Chinese statutes promulgated in the past, and you look at it, you have no idea what they are talking about because they don't give you definition of the words. Who are the subject? Who has standing to sue? What is considered a cause of action? No definition. You have to wait until the Congress publish more statutes, all the central government publish more regulations to give you a better understanding. So this civil code is a huge improvement. Book 2, real rights. Of course, it's real property rights. So general provisions, chapter 1, part 1, general provisions, general rules, the creation, alteration, alienation, and extinguishment of real rights, protection of real property rights. This book 2 is roughly the property law that China promulgated a few years ago, now incorporated into the entire civil code as book 2. Ownership, definition of ownership, general rules, state ownership, collective ownership, and private ownership. You say that there is no private ownership. Yes, there is no private ownership of land, but there are private ownership of condo. So if you buy a condo, if you buy a house, you have private ownership of the house, but you don't have private ownership of the land. You are only leasing this piece of land for 70 years. Obvious question, what happened after 70 years? One answer is we don't know yet. We're not there yet. There's the land reform, the marketization and commercialization of real estate property rights only started in 1990s. We are not there yet. Another answer you hear from the government official is it will be automatically renewed for another 70 years. So second question, why, since you have absolutely no private ownership, why you still buy houses? Why you still buy condos? What's the point? Why you not just rent? Answer, very good investment. If you purchase a condo 10 years ago in Beijing or Shanghai, now the price is 10 times or 20 times higher. It's fun. You can sell a small, tiny condo in Beijing or Shanghai and buy a big house in Zurich. No, I'm kidding. Not in Zurich, but I mean Minneapolis or St. Paul, even in New York or New Jersey. So that is a very tiny apartment in downtown Beijing or downtown Shanghai worth millions of US dollars. And 20 years ago, it was nothing. 10 years ago, only worth 10% or 5% of the current price. So that is why the real estate is a driver of Chinese economy. Next article, ownership of a buildings unit, adjacent relationship, co-ownership, and the special provisions of acquisition of ownership. Continue of book 2, rise of usufruct. General rules, rise of contractual management of land. Obviously, this, you can see the heavy influence of German civil code on the Chinese civil law. Right to use land for construction purposes, right to use a house site, right of a habitation, and even easement. So that you see how comprehensive this property rights has developed in China today. Security interest, general rules, mortgage, pledge, lien, possession. Those are the book 2, the real property rights. Book 3, contracts. Those are basically the contract law previously promulgated and now is incorporated into the civil code. General rules, conclusion of contracts, effect of contracts, performance of contracts, preservation of contracts, modification and assignment of contracts, termination of right and obligation under a contract, and even default liability. And then in the next part, they have laid out all the typical contracts. That is very common to the statutory legal system. So contracts for the supply and consumption of electricity, water, gas, and heat, utility contracts, sales contract, gift contract, loan contract, shortship contract, lease contracts, contracts for financing lease, factoring contracts, work contracts, transport contract, technology contracts, contracts for custody of property, warehousing contracts, entrustment contracts, contracts for property management, brokerage contracts, intermediate contracts, and partner contracts. And it's very painstaking detail of all the different contracts. So you have to admire the lawmakers' patience to lay out all these requirements and applicable rules for each one of these contracts. And then finally, they even include quasi-contracts. Negotium, gestio, and an-inch adjustment also have statutes to regulate those quasi-contracts. Book 4, personality rights. Bravo. Now we recognize personality rights. But reading through the list, you will see those are not really civil rights. They are not what been recognized by the Bill of Rights under the US Constitution. Let's look at it. Right to life, right to corporate integrity, and right to health, right to name and then rights to entity name, right to likeness, right to reputation, and rights to honor, rights to privacy and protection of personal information. See, they are not really the civil rights, which means you cannot, if you got arrested, you cannot go to a court of law and ask for habeas corpus protection. So life, liberty, and the pursuit of justice, those are not visible in the personality rights, but rather mostly from a very technical perspective. And in order to implement the contracts, have a cause of action in torts, protect property rights, you have to recognize those personality rights in order to going forward. But those are not political rights in the constitutional sense. Book 5, Marriage and Family, incorporated in the previous marriage law and adoption law and the succession. So what is entering into a marriage, domestic relations, divorce, and adoption. Very detailed regulations. Book 6, Succession. In tested succession, in tested succession and the testamentary gift disposition of estates. This becomes extremely big practice area in China today. Because, let's be honest, Chinese urban residents, they are wealthy. They are very rich. And so we are talking about a very common family have millions of dollars at their disposal. So the family law, marriage law, and succession law quickly become an extremely hot practice area in Chinese legal profession. Book 7, Tort liability. Oh, this is an exception. First of all, this is indeed incorporated into incorporation of the previous promulgated tort liability law. But tort liability law was not heavily influenced by German law or French law. This is the exception because it was heavily influenced by American law. The Restatement of Torts, second, published by the American Law Institute. So the tort liability law, if you read through, you see, oh, this sounds very similar to what American does in their legal system. That's true, because tort liability law is the only big legal area in China was heavily influenced by American parties instead of European parties. So damages, special provisions on assumption of liability, product liability, liability for motor vehicle accidents, liability for medical malpractice, liability for environmental pollution and ecological damage, liability for ultra-hazardous activities, liability for damage caused by domesticated animals. I have 3 dogs. I have no idea what they are talking about. Liability for damage caused by building and objects. And there's so you see that the major parts of tort liability law are very comparable to the American parties. There's a tiny book 8, basically just like 2 paragraphs called the supplemental provisions. So there are total 8 books and 1,260 provisions per than the typo. The Civil Code is the most extensive legislation in the history of the People's Republic of China and is the first and only legislation named code in the PRC. The Civil Code does not fundamentally or substantially change the civil law regime or the administrative system in China. However, the Civil Code promulgation of existing civil laws leads to numerous changes to the detailed civil law provisions governing companies doing business in China, both the foreign companies and the Chinese companies. The Civil Code regulates the basic legal norms for civil and commercial matters. It also strengthens the protection of the personality rights of individuals, such as the right to privacy and personal information. The codification of rights and obligations will not only create more legal certainty, but also create more impetus for the private sector. Contracts and property parts can have a significant impact on foreign companies doing business in China. So once there is a law, there is a code, next what we can expect is a judicial interpretation. What is the judicial interpretation? The highest court in China is called the Supreme People's Court. The highest prosecutor's office in China is called the Supreme Prosecutorate. Both institutions have quasi-legislative power. Can you imagine that? That is unthinkable in other countries, but in China, that's true. They have quasi-legislative power. After the Congress passed a law, the Supreme People's Court and the Supreme People's Prosecutorate will accordingly publish judicial interpretation to the civil code by the Supreme People's Court and judicial interpretation by the Supreme People's Prosecutorate by on the civil code to clarify and to provide guidance for the lawyers, judges, and the prosecutors how to use this law. The Supreme People's Court have already published several judicial interpretation, but so far has been mainly on eliminating the existing previously promulgated law. They interpret, okay, now we only look at the book 7 of the Civil Code for tort liability. Don't look at the old tort liability law. Things like that. They publish several judicial interpretations, but nothing substantive yet. We are waiting for substantive judicial interpretation on particular provisions and articles, instructing the lawyers and legal profession judges how to interpret these particular statutes or provisions. This is very, very important for China because Chinese language, for those of you who speak or read Chinese language, you know Chinese language is not designed for law. German language or Latin was by design, it's a very good language for law. But the Chinese language, I would argue Italian language is designed for music. La Deutsche Vita, buonasera. But the Chinese language is designed for arts and literature. It's intentionally vague and intentionally evasive to create an aesthetic value. It's not a good language for law. So we have to have a numerous interpretation and to understand it. Then we can expect the government agencies will begin to publish detailed regulations and rules. So in the coming days, we will see more and more these kind of publications to help us to understand a particular language or provision in the civil code. Of course, we will also expect a lot of legal cases will be brought into the courts under the new civil code. But as we discussed before, China is not a common law jurisdiction. Therefore, there's no stare decisis, no precedent. The court cases from the Supreme People's Court can only have a persuasive value. They are called the guiding cases. They are not really law. Last but not least, I want to share with you some quotes. One, I hear these comments from an American law professor to talk about the Chinese legal system. The big cases about politics, the middle-sized cases about influence, and only small cases deal with law. That was uttered as a criticism. But it is also true, but I would not take it as a pure criticism because, number one, 99% cases are small cases in China or in any other country. They deal with technicalities, they deal with contract disputes, they deal with property dispute, they deal with tort liability dispute. So there are only a few handful cases of big cases and a few dozen cases of mid-sized cases about influence. They are not decided by law, but the same thing as many other countries. For example, the country I'm currently residing in, the United States, the big cases are all about politics. The mid-size is about influence, and the small cases deal with the law. If you look at the United States Supreme Court, and every single big cases, they are intertwined with political considerations. And highly ideological conflict decided outcome of many important big cases. Second quote, Aristotle, law is order and good law is good order. Why China won't have a civil code? Since you have a party controls everything, why bother even to promulgate the law? Because we want order. Because the party want order. They want the good order. They want to publish good quality law to maintain a good order and to ensure economic development. And finally, Dwight Eisenhower, the world no longer has a choice between force and law. If civilization is to survive, it must choose the rule of law. Obviously, China decided to choose rule of law. That's good enough to me. But I think it's a much better option than the choice of force and the choice of violence or choice of war. So in this regard, I commend and the publication and the implementation of the Fourth Civil Code of China. My time is running out, and I'm going to just provide my contact information to you. For the next few months, I will still be in the United States, and this is my law office. And I'm hoping by the end of the year, I shall be able to return to Beijing to teach. Currently, I've been teaching on Zoom for 2 years. I enjoying it, but I really need to see my students. Otherwise, I like face-to-face interaction. So feel free to reach me out if there's anything I can be of assistance to you. And so I think my time is totally up. I want to thank you so much for your attention, and thank you, Professor Ferraro's kind invitation. I consider this a privilege to have an opportunity to interact with you. I look forward to our future collaboration, and maybe one day in a restaurant in Rome or somewhere, and we will have a glass of Chianti and have some good Italian food. And I welcome all of you to come to Pekino to visit me, and sometime next year or going forward when this pandemic is over. Again, thank you for your attention. And I'm not sure if we have time for questions, and I will just go back to Professor Ferraro.